Uh,
Okay then.
Hello, everyone. So I would like to introduce you here, Stephanie. She's in Italy. She has been working in as a GDPR role, and which is the data protections in the European Union. We know that when European Union introduced this GDPR law and compliance, most of the big organizations like Google, Amazon, Apple, everyone is having really trouble times doing the business in Europe. The most reason is if you don't follow the GDPR law, you get almost, I don't know, it's a 4.5% of penalty from your annual revenue. And so I remember last year, Google, they paid a huge amount of money to the European Union. So it's not about the penalty when GDPR comes. It's all about the company reputation, branding. And we have seen, especially in United States of America, a lot of small and medium companies every single day, not every single month, every single day, a lot of business, they go out of business because of the data privacy. If they don't maintain the properly data, they don't secure the customer and user data, if they don't preserve the proper credit card informations or privacy data, then end of the day when it's compromised, they get a big penalty from the government. In the same time, they lose the customer. So Stephanie, I know that you have been working a long time and you are doing the PhD also in the subject. So you have a huge experience working in the all over the Europe, especially in Italy region. So I would like to give you the floor now. Thank you.
Thank you very much. Can you hear me? Everything is okay?
Yes, we can hear you.
Oh,
Very
Yeah, you are audible.
perfect. So hello to everyone. Before starting, well, Adam already presented me, but I would like to do it again. So my name is Stefania Hrlaiello. I'm a researcher in the field of law innovation and a young specialist in the field of data privacy with experience in GDPR that I obtained in some of the previous years. So I'm going to share my screen now. Okay. I hope you can see my screen.
Yes, we can see your screen.
So I will give you a very brief insight to the GDPR and explain what is it and what it means to all of us. So GDPR is the abbreviation for General Data Protection Regulation. The full name of this regulation is Regulation on the Protection of Natural Persons with regard to processing of personal data and on the free movement of such data, and repealing Directive 95/46, the Data Protection Directive. It was adopted in 2016 and implemented on the 25th of May of 2018. It comes, of course, out of the European Union, and simply it is a set of regulations that is designed to give EU citizens more control over their data. So the previous set of rules was called the Data Protection Directive, and it hasn't been updated since 95 until this new regulation. So why has it happened? The answer is obvious. Times have changed. We collect data, we move data, we transfer data, we target with data, we do many things with data. So we simply had need to create something more modern. So a quick overview to where the GDPR actually comes from. It is important to say that in Europe, privacy is one of the fundamental rights. So data is very valuable. It can help us build new tools and gain new insights that are good for people and for the economy. But the flip side is that all this personal information can lead to intrusions and interferences with other people's private lives. And that can be very damaging for individuals. So it is vital that data protection laws are underpinned by a respect for fundamental human rights. That's because the storage and use of personal information should be at service of people. To ensure that this happens, the data protection laws should take into account people's rights to private and family life, which is protected by the Article 8 of the Human Rights Convention. And it is also very important to mention the Charter of Fundamental Rights of the European Union. It's still the Article number 8. Protection of personal data. So this is where the GDPR finds its roots. So the important thing to take from this is that the right to privacy in Europe is a fundamental human right. So that being said, who does the GDPR apply to? That is the question. So a lot of people are thinking, okay, we have a physical location outside of EU, so the GDPR doesn't apply to me. Well, that is not really correct. Article number 3 of GDPR, called the territorial scope, says that the regulation applies to the processing of personal data of data subjects who are in the union, etc. So let me move this, sorry. So this is the way it works. It goes around the residency, it goes around the EU citizenship. So if you're collecting data from an EU resident, regardless of where you have a physical location, GDPR applies to you. So for example, if you are some kind of provider of an online service, or you are a processor of data on behalf of another customer, and that customer gets data from EU residents, then GDPR applies to you. So the regulation obviously applies if the data controller or processor, and I will talk about it in a few moments, or the data subject is based in EU. So it also applies to organizations based outside of EU if they collect or process personal data of individuals located inside of the EU. So that is the territorial scope of the GDPR. So now that we know a little bit about who it applies to, I would like to introduce you to some main notions of GDPR. So I've been mentioning a lot personal data. So let's try to understand what kind of data are we talking about. So GDPR uses this phrase. This is the definition from the regulation you can see on the screen. And the GDPR uses this phrase, personal data. The way GDPR is written and the way we refer to it, personal data means kind of what you would expect it to mean. Like name, email, address, phone, date of birth, national identifier, you know, things like that, things someone would expect. But the notion of personal data is actually much broader than just that. It also includes things like online identifiers, such as cookies, tags, IP addresses, GPS locations, everything that makes a person identifiable. It includes a whole category of special categories of sensitive data like religion, ethnics, political, genetic, biometric data, sexual orientation, health, financial data, and if you collect any children's information, generally speaking, GDPR treats children under the age of 16 but there are also some member states that might treat children that are actually under the age of 13. So when we think about personal data, we really have to understand what we're collecting and how we're using it. So as an example, you have to pay lots of attention to these sensitive data. As an example, if you're collecting HR benefits information and you offer domestic partner coverage, you might ask, what is the gender of that domestic partner? And in that case, you also know the sexual orientation of the person. Or for example, if you're asking for the dietary needs and then someone just marks kosher, then you also might know that that person is of a Jewish religious orientation. It is very important to really understand what kind of data you're collecting, where is that data, and how is it being used. The next notion I would like to talk about is a consent. And the consent is one of the crucial notions in the GDPR because the GDPR sets a very high standard for consent. It must be unambiguous and involve a clear affirmative action. It's basically an opt-in. Consent means that offering individuals real choice and control. A consent should put individuals in charge, build trust and engagement, and enhance your reputation in the end. It specifically bans pre-ticked opt-in boxes, and it requires a distinct, granular, consent options for distinct processing operations. Consent should be separate from other terms, in other words, and conditions, and should not generally be a preconditions of signing up to a service. It is very important to keep clear records to demonstrate consent. GDPR gives a specific right to withdraw consent. So you need to tell people about their rights to withdraw and offer them an easy way to opt out at any time. Consent is one of lawful bases for processing. There are also some alternatives. Consent is appropriate if you can offer people real choice and control over how you use their data and you want to build their trust and engagement. But if you cannot offer a genuine choice, the consent is actually not appropriate. If you would still process the personal data without a consent, asking a consent is somehow misleading and in the end also unfair. So what is a valid consent? Consent must be freely given. This means giving people genuine ongoing choice and control over how you use their data. Consent should be obvious and require a positive action to opt in. It must be prominent, unbundled from another terms and conditions, concise and easy to understand and user-friendly. In conclusion. So, as I mentioned before, you heard me talking about these ideas of controller and the data processor. And I will talk a lot about this, but I'll try to explain for a moment these definitions here. So an example, a data controller, it's a kind of what it actually sounds like. You're a company that controls the data that you receive. You make decisions about what's going to happen to that data. You are the ones who are actually collecting that data and determining how it's going to be used during the process. On the other hand, if you're a processor, you process data. And you're processing data at the direction of the data controller. Most companies, not all of them, but most, are data control in effect, or they would be considered a data controller. We're talking about things like HR data. Of course, if you have any EU employees, finance data, if you're paying and EU clients or partners or employees in the end. So those sort of back office operations are often on the controller side. You could have the whole company being a data controller and a data processor. But you could also be a processor of somebody else's data, but still parts of your company, like your finance, marketing, and HR parts could be on the side of controller. So it is important to understand those differences, and we will talk some more about it. And the really important thing is to know is that GDPR treats all the people in the same way. So no matter if you're an employee or a customer or a vendor or a partner, GDPR basically doesn't make any difference between those subjects. Anyone who you're collecting personal data to is sort of treated equally in this regard, and the GDPR applies equally to them. There are some extra elevated controls for HR data, but at the base of GDPR, it applies to them in the same way. Okay, so now that I introduced you to some basic notions, I would like to talk about rights of data subjects. So GDPR introduces a variety of different data subject rights, and I will just talk about some of them here. So one of the really big ones is the right to be forgotten. This is the concept of I can delete my data. So any user, any subject can request that their data can be erased. This can happen when the personal data is no longer needed for the original purposes, and also individuals can withdraw consent for any data processing. This action has to be taken without any delay according to the regulation. The only exceptions to this are reason to public interest, public health, and some scientific and historical research. So maybe some of you might remember that famous Google case that happened some years ago. Adam mentioned Google. And that was actually about people's right for their data to be deleted. So to be able to be deleted, you have to know as a company where your data actually is. So if I send a note and say, hey, I want you to delete all of my data, are you aware of where I am, what data you have on me? Where do I sit? What's the process internally? What conditions have to be met? So do you have a process in a place? Because that request might come through a customer service or any compliant line or variety of different places. And you really need to know how and who is going to be the final person determining that request. So sometimes data actually cannot be deleted, and you might have to keep some of them or all of the data for different reasons. Those reasons can be legal reasons, tax reasons, or other regulatory purposes, perhaps in the interest of public health. As I mentioned before, there are actually some exceptions when data cannot be deleted. So again, that process of being able to circulate the request to the right group of people internally to determine. And the answer to the question, if you can fulfill this, is really important. And the other important thing is that it has to be met with what we call undue delay. I already talked about it before. You cannot take really months and months to figure it out. It has to be done as soon as possible, which means that there has to be a very tight relationship between the data controller and the data processor. And as I mentioned before, the data processor takes directions from a data controller. So if someone wants to request their data to be deleted, it really needs to start with the data controller. And the data controller is the one who makes the decision. And when the data controller says, yes, we need to delete this data, he has to communicate that to the processor. And from that moment, the processor has to delete that data. So it means also that you have to have a process in place to be able to receive that request and to know where all the data is for your customers to be able to manage that request. So you have to really ensure that you have technical capabilities and as well the business process to comply with this thing. The next important right is right to data portability, and the requirements for the technical capability and the business process are just the same as I described for rights to erasure. So let me explain for a moment what data portability is. So this is about being able to move my data from your system to a potential competitor. So let me just highlight that it only applies to automated data. So if you have a stack of paper, it doesn't apply to that. So the idea is that I can see all the information that you have about me, and I want to be able to move it somewhere else or to someone else. And so, like I was saying, it is important to have a balance of a technical capability as well as the business process. And it is also important to make sure that your employees are well trained for those procedures. So just to give an example of rights to data portability, that would be the case if I would like to change the mobile phone provider or the internet provider, for example. Okay, so I will just briefly mention the other two rights, which are also very important. Rights to rectification, which is the right of the data subject to obtain from the controller without undue delay the correction or a completion of an inaccurate or incomplete personal data. And then there is also the right to object on grounds relating to his or her particular situation at any time to processing of personal data concerning him or her. Basically, you have the right to object to an organization that is processing your personal data at any time. And this effectively means that you can stop or prevent the organization from using your data. However, it only applies in certain circumstances, and they may not need to stop if the organization can give strong and legitimate reasons to continue using your data. So you can only object to processing when the organization is using your data for a task carried out in the public interest, for the exercise of official authority, for their legitimate interests for scientific or historical researches or statistical purposes, or for a direct marketing purposes. So those are the rights of data subjects. So now that we know a little bit about the basics of GDPR, the question is, why should we care? Why should everyone care about GDPR? So there are a variety of reasons, actually. The first is, I don't know if you've been reading headlines, but Adam mentioned it too. There are massive fines that can come from just a single violation. So the GDPR says that those fines can be up to 20 million euros or up to 4% of total worldwide annual turnover of the preceding financial year, whichever is higher. So obviously from a financial perspective, that is a very big hit to any size company. I mean, companies can even close their businesses because of that. But beyond just the financial part, there are some other reasons why we should also care. So the second thing is that customers, EU customers, actually are expecting this. So since it's a regulation and it's a requirement, companies have to adhere to it. And so there is a certain level of expectation. If you're a processor, for example, and companies are coming to you asking, are you GDPR compliant? And you are going to want to do that to maintain that business because there is the expectation for that you do that. And finally, it is actually a competitive advantage. And additionally, understanding of where the data is in the company in the end and how is it used, that helps you being more effective and efficient in business decisions because everything is in a centralized place. So that is actually a really good thing because if everyone ever asks you about a question about the X data, we might be wondering, well, I think it's in the system over here, but I'm not totally sure. And now you actually have the ability to know where it exactly is. So I mentioned briefly the consequences and costs on the first place of a non-compliance. If a company doesn't comply, there are some really significant fines, as I already mentioned on the way. A company could also lose customers. That is important. If someone asks you, are you GDPR compliant? And the answer is no, I don't know, maybe. They just turn around and go to and find someone who actually is. It makes us lose trust. This is all about being able to protect someone's data. And when there is something that we're not quite meeting, we could lose someone's trust. With all those different data breaches, it's really hard to regain a customer and then think about how much it might cost to get a new customer and how about all the different data breaches that have been out there. Each member state, it is important to mention that each member state actually has its own local protection authority. And those are the ones who manage incidents. So they could come and knock on your door if there is a reported violation. Now that I already mentioned the Data Protection Authority, let's see a little bit what is the procedure in the case of data breaches. So when it comes to data breaches, under GDPR, it is required to inform authorities within 72 hours. You have to also keep in mind that not all incidents have to qualify as a data breach, but if they meet that definition of data breach within 72 hours, you have to inform the local authority. So 72 hours is the time frame. That is a really tight time frame. And the notion of our controls and processors come back again in this 72 hours frame. Important to say that 72 hours doesn't mean 72 business hours. So holidays and weekends are included. So, you know, the clock starts ticking. for a controller, but even a processor if he has a data breach. So again, you can see how strong communication is going to be required between a data controller and a data processor. So if you're a processor, you need to make sure that you have a clear communication to your data controller. If you're a data controller, you have to make sure that your data processor has a really strong security program and are able to identify data breaches quickly, timely, and communicate them to you. I also usually encourage clients to review and update their incident response plan, because planning is your best medicine in that moment. It might not really exactly go as you planned, but you will be in a much better position if you actually have a plan. So if you have the list of people internally that you're going to be calling or contacting, I don't know, a short list of forensic and attorneys, that is a great thing. Also a template that you can create for communication purposes to your controllers or processors, or to your customers, or to the outside world. So if there is an incident, you will be able to better spend your time, to better spend those 72 hours diffusing the incident and having it managed. So another big consideration when it comes to incident response plans and managing data breaches is to do you know what should you put in a mail? How should it go? You know, how the phone calls should be going, you know, and all of those things should be actually decided much in advance, because you have only 72 hours. So in the context of data breaches, I would like to mention some other points. So in the world of GDPR, there is also this really big notion of transparency. It can be seen as the correlation of what you do and what you say. So this is accomplished through a privacy notice. A privacy notice has to be concise but complete in a very plain language that everyone can understand. So right before I give my data, I need to know what are you planning to do with it? How are you going to use it? Where are you going to share it? What's going to happen with it? What is the range of time? So all of those things have to be outlined in that notice in details. The next point is the minimization. The whole idea of the GDPR is that I want actually to minimize the risk for the personal data that I'm collecting. Minimization in the sense that you only collect what you actually really need and only share what for the time you're only gonna collect data that you're gonna use for a certain period of time and that you absolutely need. So no extra data. Oh, sorry. It is also very important to mention one more actor, and this is Data Protection Officer, the DPO. The DPO is appointed in the organization if you are a public authority or a body, or if you carry out certain types of processing activities. DPO is the figure that is responsible for overseeing a company's data protection strategy and its implementation to ensure compliance with GDPR requirements. It can be a crucial figure during the breach. So DPOs assist you to monitor internal compliance, inform and advise on your data protection obligations, provide advice regarding data protection impact assessments, and act as a contact point for data subjects. So maybe you might have heard that you need the DPO if you have 250 employees or less. Sorry, that you don't need a DPO in that case. But actually, it really is connected more with the type of data that you're collecting and processing. And if you're collecting really large amounts of data, so you might have to appoint a data protection officer if a kind of processing that you're doing fits in those categories. A DPO generally reports to the highest parts of the company and to the board, and can be a contract person, or it can be a part-time person in the company, it doesn't matter. But the DPO's job is to help them figure out the best strategy for using data and ensuring the overall program. So let's go for a moment to breaches and fines, and take a look to some of those fines that were imposed in previous years. So for me, my favorite one is the first one, the Italian telecommunications operator, the Wind3 SPA, that has been fined approximately 16.7 million euros for violating data provisions of the GDPR. So they've been unlawfully processing some personal data. Then, as we all know, Facebook was fined £500,000. So they basically improperly shared the data with the third-party developers without a consent. Google, which did not comply with the right to be forgotten, as I already mentioned before when I spoke about this right. So, just a few conclusions. We talked a lot about what is GDPR, who it applies to, the type of data, a bit about transparency in the notice and the data rights. The important thing to remember is that GDPR is applicable to all organizations which control and process data of EU subjects. Data processing obviously may happen even outside of EU in a third country, in which case GDPR applies. And it's always important to remember the consequences and on the first place, high costs of non-compliance. So that would be it.